Why is it necessary to understand the nature and goals of transitional justice in a sense where traditional systemic criminal justice is fundamentally different from transitional justice? Often transitional countries consider trying their former leaders autocrats who have committed war crimes or crimes against humanity or have oppressed their subjects and citizens in the most horrific ways. They consider trying those people before the existing criminal courts, trying them through the systemic criminal justice system, and they consider justice as reachable in this way. This is an illusion. Autocracies create autocratic and criminal and corrupt judiciaries, and the prosecutors and judges in such societies tend to be the primary perpetrators of the injustices and violations of human rights that are typically attributed to the top leaders, because the top leaders would not have been able to commit those crimes without the active participation and the immediate perpetratorship by judges and prosecutors. So the whole goal of transitional justice is fundamentally to replace systemic criminal justice, to offer alternative ways of implementing criminal justice outside the systemic arrangements of criminal courts and prosecutorial offices and the criminal procedural laws. Transitional justice typically includes the setting up of special courts with special prosecutors that operate under statutes that offer them special procedures. So they operate outside the systemic criminal justice system on a procedural level and on the status level, because there are different courts and with different actors, special prosecutors and special judges. These courts, sometimes they are called tribunals because they are not part of a systemic criminal justice architecture. Sometimes these courts focus on specific violations, on specific crimes, on specific areas where these crimes have been committed, such as the courts that have been established to try war criminals in places such as Rwanda or Bosnia and Herzegovina, the former Yugoslavia. And sometimes such courts are established to address issues within a particular country. They're established by a transitional authority or by the people who have rebelled and risen against the autocracies that had oppressed them previously. And such courts inevitably must be understood as parts of a political process. The aim of transitional justice is not simply to implement any kind of traditional justice, either criminal justice that is seen as giving people their dues, treating them according to their desert, giving them what they deserve, which is the retributive way of understanding criminal justice, or by trying to prevent the same or any other perpetrators from reoffending in the future, which is called special and general prevention. And both are part of a utilitarian concept, or consequentialist, broader speaking, consequentialist understanding of criminal justice. Nor is the goal of transitional justice to effect a reformation of the offender, to re-educate the offender so that they become a better person. This is the most idealistic and the most unrealistic approach to criminal justice. even within the traditional national criminal justice systems. No, none of these is the goal of transitional justice. Transitional justice serves the purposes of political transition. Its aim is to send a strong message to the citizens, to those who have been oppressed. This message is a value message, and it is the emphatic rejection of the practices and values and behavior of the previous regime and all the perpetrators who acted on behalf and within that previous regime, and a firm affirmation, embracement of completely different values. And this is why transitional justice must be fast, must be quick. There must be procedures which allow for quick sentences, for quick convictions. It must be fairly radical. And the punishments envisaged by transitional justice include long-term imprisonment, and I would argue that they should include a death penalty, because the execution of those who had committed the most grievous crimes against human rights, such as the corrupt judges and prosecutors who had imprisoned innocent people, who had knowingly and wantonly for years and decades abused the vulnerable, snatched children away from their parents and sold them, or abused families because their members were opponents or critics of the ruling regime, caused people's deaths in custody, mistreatment of individuals, covered up political murders and things like that. These judges and prosecutors need to be tried quickly under transitional justice. They need to be executed. Only in this way will the value message, the transitional message, will be sufficiently clear and sufficiently strong. It will be communicated effectively. Transitional justice is a form of revolutionary justice. It is not revolutionary in the sense that it doesn't involve summary executions of everybody who might jeopardize the aims and stability of the outcomes of a revolution. But it is similar to revolutionary justice because just like revolutionary justice, transitional justice involves harsh penalties, involves quick procedures, very limited, if any, opportunities for appeal, and quick execution of the sentences. It is part of the process of dealing with the violent past, because just like one cannot deal with a violent offender without applying counter-violence, without applying countermeasures to overcome and overpower the offender, in the same way one cannot deal with a violent regime, an illegal regime, which in many cases would have thrown at their feet any remnants of legality and legitimacy in the treatment of their opponents and of the citizenry at large without being violent. So while we must remain civilized and cannot allow public lynching, what we do need to do is to offer the public the satisfaction and the sense of closure which arise from the quick, effective, public and harsh punishment of those who had poisoned the very moral structure and the very moral substance of the society. So, while I must say that in my country I was instrumental in the process of abolition of the death penalty as the member of the working group who initiated the abolition of the death penalty, and the working group as a whole, the working group that was tasked with changing the criminal law as a whole, embraced that idea and proposed a criminal law which basically ruled out the death penalty in the case of transitional justice. So although I was likely the instrumental individual, the most instrumental individual in the abolition of the death penalty in the criminal code of my country, in the case of transitional justice, I support the death penalty. And I think that in countries that have arisen from a dark period of authoritarian repression and long-term abuse of political office, and especially of the judiciary, transitional justice should include special courts which can be called courts of political and judicial crimes, where primarily the members of the judiciary, whose actions are in such circumstances the very reason for the introduction of transitional justice, so the members of the judiciary should be tried under the threat of the death penalty. I even think that in some cases, when the suspicions and charges are so grave, particularly grave for the abuse of prosecutorial and judicial powers, such as in cases of abuse of the vulnerable, or children, the snatching away of children from the political opponent parents, such as was the case under the Pinochet regime in Spain and under the regime in Serbia that's been in power since 2012. In such cases, I think transitional justice should involve the trial of judges and prosecutors under the sole possible penalty, which is the death penalty. No other penalty should be possible. There should only be one outcome in case of conviction, that is the death penalty. And this way, transitional justice would basically produce the results that are expected of this part of the transitional process. We have to understand, as Klaus Bachmann and I wrote in a relatively recent, few years ago, paper on the political nature of transitional justice, that if we try to relativize, water down this goal of transitional justice, which is to support the transitional process overall and to send clear, semantically simple and emotionally, value-wise strong messages to the public. If we water this down and try to sort of use transitional justice and the special courts for political and judicial crimes in the same way that characterizes the regular operation of ordinary criminal justice system, courts and prosecutors, the transition process will fail.